Okay, I think we're going to get started here. My name is Jeff Sutton. I'm a judge on the Sixth Circuit, and I have the good fortune of moderating this panel. Earlier today, Ted Cruz was on a panel, and he said, I thought jokingly that during the history of the Federalist Society, there have been 6,000 and something panels on federalism. Now, that's a pretty good line. Then I looked at today's program, and I realized there were actually 4 panels just on federalism, and I started to do the math, and maybe he's not that far off. Reminds me of the committee man in Congress who was 25th in seniority. The committee's debating a bill. It finally gets to him, 25th person to speak on this bill, and he says, everything that could possibly be said about this bill has already been said, but not everyone has said it. So we have a little bit of that today. But if you look, the first panel today was titled Enumerated Powers, the 10th Amendment, and Limited Government. 6.5 hours later, it's pretty depressing. The panel's entitled, Is There Any Remaining Limit to Federal Power? So it's not really been a great day for federalism at the Federalist Society. We do have a terrific panel, and we're going to follow the traditional format for these conventions. Each speaker's going to talk for kind of the 10 to 15 minute range. I'll then get the conversation going with a few questions from the bench, we'll call it, and then we'll open it up to questions from everybody else. Our first speaker is Professor John Eastman, who happens to be a teacher, author, and litigator in the area of federalism. I've read a bunch of his stuff. It's terrific, it's provocative, and he seems to be one of the few people out there trying to look for principles that judges can actually apply in cases. He's the former dean and a current professor of law at Chapman University. And John, we're glad you're here, and if you'd go first, that'd be great.
Thank you. Thanks so much. As we were kind of sharing notes and figuring out how we were going to allot our time and our subject matter, it occurred to me that I'm going to give a very pessimistic view on on the answer to the question here, and that there isn't really much that the federal government can't do under current precedent, and I think that's a bad thing. And then I think Jeff's going to give a very optimistic view that there's a lot they can do, and he thinks that's a bad thing. got it backwards. But I want to shift a little bit, and I want to take on Michael Gerhardt's comments this morning, that he thinks it's a good thing that no one is looking at the courts to save the United States. I have a 180-degree opposite view, that no matter what of the structural changes we put in place, if we get the rescission amendment through, if we get the, have a new constitutional convention that tightens up language that is actually pretty tight already about the limits on federal power, that somehow we don't have to have courts providing the check on the legislative branches that the founders of the Constitution envisioned. And the notion that we ought to have just simply a political check on it, as he argued, seems to me completely antithetical to their understanding and threat of majority tyranny. And it completely undermines the notion that you have a written constitution that binds the elected officials who are operating under it. And if we want to have a written constitution that actually has some purpose to it, including binding majorities, however transient they might be, then you have to have a check on the political branch, because they're not going to check themselves by definition, by nature. And the founders understood that, and it's one of the reasons we have an independent judiciary. And quite frankly, I don't think we can win this fight long term until the judiciary gets back into the game. And all of their deference decisions and everything else that they do to avoid having to participate in that duty of theirs. Marshall calls it a solemn duty way back at the beginning. It's not one that we relish, but it is, when we're presented with something that violates the terms of the Constitution, it is our solemn duty to take it. It's not judicial activism to say that the Constitution prevails over a statute that violates it. And we have got to develop notions that get the courts back into that game if we're going to prevail in the long term on checking the size and scope of government. And so I want to talk about kind of 3 principal cases, 2 this past term, and then one a little bit older. The one that's a little bit older is the medical marijuana case from California, Raich. I think it put an end to the signature accomplishment of the Rehnquist Court's revival of limits on federal power revolution, Lopez. I think Lopez, United States versus Lopez, when you look at it, basically overruled the old Wickard versus Filburn case. They didn't say so. They went out of their way to say they weren't doing that, but you can't reconcile those two opinions, it seems to me. And all of the efforts to reconcile them since then have been rather phony and specious. And so when you're confronted with the medical marijuana case out of California, they have to face that question head on. Did we overrule Wickard and restore the notions of limited government, or are we going to make Lopez the anomaly? And unfortunately, 6 members of the court said Lopez is the anomaly, and that's what that. And it's very discouraging to me that they did that. Then you get to Comstock this past year, and Comstock's kind of a sleeper case. The vote there is 7-2. Only Justice Thomas and Scalia in dissent. And here we explicitly allow the federal government to engage in police power regulation beyond anything that the enumerated powers given to them would allow. They bootstrap a federal crime into incarceration in federal prison, and then when I release somebody from the federal prison, if they're a sexually violent, mentally insane predator, I can then civilly commit them. But the point that they are no longer under my jurisdiction because of the federal crime is the point where the enumerated powers doctrine, even with the broadly understood necessary and proper clause, ends, and the federal government is now exercising vintage police powers that belong to the states. And there's just no way around that. Read Justice Thomas's dissenting opinion in that. It is impeccably well-reasoned, and it's absolutely right. And yet only 2 votes. We don't pick up Chief Justice Roberts. We don't pick up Justice Alito. We don't pick up Justice Kennedy. And it seems to me that is a very dangerous trend, that the necessary and proper clause now becomes an ends power in and of itself, that some means to enforce some other enumerated power itself becomes an end, and I can adopt new means to enforce that end, anything that's collaterally related to it. And this will, to use the language of prior Supreme Court decisions, go a long way toward destroying the difference between national and local, and go a long way toward vesting the federal government with an absolute police power. And I think that teased out of the reasoning of that opinion, particularly in light of that 7-2 vote, you're going to find that there's not much that the federal government cannot do if they want it. Now, Justice Kennedy's concurring opinion in there does have some salutary language. He picks up something that Justice Scalia started toying with way back a decade and a half ago in Prince versus United States. There's always been this kind of confusion on enumerated powers doctrine versus 10th Amendment sovereign immunity. And the confusion comes from the text of the 10th Amendment that makes it look like a truism. If the powers are not delegated, they're reserved. And so they're 2 sides of the same coin. Well, then we start talking about, well, some powers that are probably delegated nevertheless are reserved because they go to the core of state sovereignty. And this kind of new 10th Amendment idea, separate and apart from delegated powers doctrine, takes root. Justice Kennedy picks up in his concurring opinion in Comstock the notion that if it is intruding on core state sovereignty, then it would not be proper. And so it doesn't fit within the necessary and proper clause, and therefore it really is this kind of 2 sides of the same coin argument. And I think that's exactly the right way analytically to approach necessary and proper things. It takes account of state sovereignty. Unfortunately, Justice Kennedy, after laying the high watermark on this argument, doesn't follow it. And then the other thing he does, and I think he's right about this as well, he says the necessary and proper clause can be more than 1 step removed from the enumerated power. And he's surely correct in that. We've got all sorts of statutes that are means that are necessary to advance the other means that are also necessary to advance the necessary and the enumerated power. But the 1 step removed doctrine was an old proxy for it's too attenuated to the actual authority of the enumerated power. Unfortunately, the way he then approaches the discussion, he throws out that underlying issue, the too attenuated principle, with the argument. And he's got a wonderful line here. He says the analysis depends not on the number of links in the congressional power chain, but on the strength of the chain. And he's right about that. But I wish he would have applied that reasoning, because he would have had to vote in dissent in that case and maybe bring the other 2 with him. And now the other thing he does, and I think this is very useful as well, but again, it's a 7-2 decision, so this opinion concurring in the judgment has got no binding effect whatsoever. There's language in the majority opinion of the court suggesting that we apply a rational basis test to necessary and proper clause inquiries. And he rejects that out of hand. That's a due process test, he says, not a necessary and proper test, and I think he's right about that as well. I think this is a dangerous opinion overall. I think there's some stuff in Justice Kennedy's concurrence that can be teased out and applied to try and restore some limits on federal power, and it's always nice when you've got a 5-4 court with Kennedy in the middle to use his own words to try and further advance the ball down the road. Unfortunately, his own words didn't seem to limit his going the wrong direction here. Now, the other case I want to talk about briefly, and then I think I'm almost out of time, is a case that the court did not take. And I think normally that's not significant at all. This one I do think is significant, and it's disheartening to me. Partly because it was my case, but partly because ever since Lopez in 1995 and the restoration of limits on the commerce power, everybody has known that we had to confront the issue whether there were parallel limits on the spending power. Otherwise, the Lopez Revolution was meaningless. I mean, if I can't have guns in a school zone by direct statute, all I do is make it a condition on the federal money to the school district, and I accomplish exactly the same thing, and it's just a formalistic thing for Congress to check another box when it's going through Congress. It's no real limit on the expansive scope of federal power. And there are parallel restrictions in the spending clause comparable to those in the commerce clause, if the court were willing to take it up. And as Judge Sutton pointed out, we're looking for ways to give the courts judicially definable lines that they can draw. And if you look at the general welfare clause, there is such a line. It's not where they're going to second guess whether this advances the welfare, but is it general rather than local? That's something that the courts can easily draw. And it's something that both Hamilton and Madison agreed on. It's vintage originalism, no matter which of the two polar opposite views of this thing you take. They've toyed with this issue a couple of times, saying we're not going to take it up here because the parties didn't raise it or the lower court didn't address it. And we had a case this past term, Cisney versus Reich, where the lower court addressed it in several pages. It dealt with religion, the prison side of RLUIPA. Religious Land Use and Institutionalized Persons Act. And South Dakota decided to draw a line in the sand and say, we're not only challenging the conditions you've imposed upon us, but we're challenging the spending program where you're taking our money, giving it back to us to fund our own local prisons, and then adding all these conditions. We don't think the money itself is constitutional. The court, 8th Circuit, had to deal with it. It says there's no other power in the federal Constitution, no commerce power, no nothing that would authorize this other than the spending power. I have to confront the spending issue. He spent several pages on it, and it's taken up. And the court denied cert on it. Now, this is not an issue where you're going to get circuit splits. Not too many states are going to challenge the money that they're getting from the federal government. This was teed up for them, and if there was any way to kind of put that genie back in the bottle and have the court just re-enter the game a little bit, it was that case, and they passed on it. And I'm fearful that the consequences of that for a lot of other spending programs. Now, we'll get legislatures on occasion in an election that will limit their earmarks and all the other stuff they're going to do. It's going to be at the margins, and it's always a one-way ratchet. We'll hold the ground for a few years here, and it'll start ratcheting it up, and then maybe we'll hold the ground for a few years, and the next thing we know, it'll be 100 trillion rather than 14 trillion. And until the court gets back in the game by saying there are some things that the federal government can't spend money on, local projects being the best one, then we're never going to trim the size of that. And so those three things combined lead me to be fairly discouraged. Will the recent election embolden the court to say, well, we've got some folks in Congress that maybe agree with us now. Maybe we ought to get back into this game. But see, that just sounds too much like the political check, which gives them the excuse to stay out of the game. And I think they need to get into the game, and I think we need to encourage them to it. And I think state legislatures need to encourage them to it. And I think preambles to federal legislation needs to encourage them to it. And authorization bills needs to mandate that they do it. I mean, every possible way we can get, because that's the check on expansive federal power that I think the founders put most stock in. Thanks.
Thanks, John, for that very upbeat assessment of judicially enforceable limits on federalism. Our next speaker is also an author and professor, Jeff Rosen, professor of law at George Washington University School of Law, and also the legal affairs editor at the New Republic, who's written several books, including most recently, The Supreme Court, The Personalities, and Rivalries That Defined America. So, Jeff, thank you.
Thank you so much, Judge. It's always a pleasure to be at the Federalist Society, and I always learn something new. Although I have to say, Judge Sutton, that if there have been about 6,000 Federalist Society panels on the limits of federalism, I must have been at about 4,000 of them. I sat on this very platform 2 years ago, in 2008, and it was the same topic, the future of federal power, is federalism dead? And I have to say that the mood was far more gloomy than it is now. Obama had just won, the audience was looking downtrodden and full of despair, and speaker after speaker announced, federalism is dead. And several people quoted Michael Grieva's gloomy comment from 2005 that in the wake of the Raich decision, federalism had found no takers. Justice Scalia had defected. Et tu, Justice Scalia was the general thought of the day, and that if even he wasn't willing to resurrect limits on federal power, there was no hope. Well, what a difference 2 years makes. We've had a Tea Party election. There have been triumphs of Tea Party candidates in Congress. Constitutionalist rhetoric is ascendant. And what I want to argue today is that of the three strains of legal conservatism of the past 30 years, the two that favor limits on federal power now may be in the ascendant in a way that they weren't 2 years ago. So the three strains I want to discuss are first, Chamber of Commerce conservatives, second, libertarian conservatives, and third, Tea Party conservatives. And there are similarities among these groups, but there are significant tensions and strains among them, and only the Tea Party people and the libertarians really want to resurrect limits on federal power. I'm going to go on to argue that I think it's far more likely, John, that in wake of this election, the lower courts and the Supreme Court will, in fact, recognize limits on federal power. I would have said that the challenges to health care were far-fetched 2 years ago. Now I wouldn't at all be surprised if they succeed, because the courts, for better or for worse, do follow the election returns. As the savvy Tea Party movement realizes, they are to be commended among those who disagree with them vigorously, as I do, for having a two-part strategy, recognizing that constitutional change comes from the ground up, and that first, by achieving political victories, you can change the judicial climate in a way that can lead to judicial victories. And that has been the pattern throughout American history, and I think it's likely to happen now. And then finally, I'll just end with a little finger-wagging exhortation of you to recall your founding principles and regret the fact that it's now liberals rather than conservatives who are the party of judicial restraint. And I know we'll have a big disagreement about what that means, as we do every year. But at this time, you guys are cheerful, and I'm the one who's depressed. All right, so here are the three strands of legal conservatism, and I have to say, having written about each of these at different times, I've often underestimated the tensions among them. But let's think through them for a second. Chamber of Commerce conservatives, libertarian conservatives, and Tea Party conservatives. The libertarians are represented by my friends at the Cato Institute and the Institute of Justice. Their intellectual leader, people like Randy Barnett and Richard Epstein. The Chamber of Commerce conservatives are more concerned about uniformity of federal regulation, are more willing to favor preemption doctrines, and are less concerned about states' rights. They have a shared commitment to free markets and deregulation, but very different goals. The libertarian conservatives want to limit federal power to protect states' rights. The pro-business conservatives are willing to extend federal doctrines like preemption to protect the national uniformity that business interests require. And you see this in the disagreement between Justices Thomas and Scalia, where in some of those preemption cases, Justice Thomas, sometimes in dissent, is willing to stand up for states' rights, and Scalia is more willing to recognize doctrines like preemption. The ideological differences between these two groups are seen in their disagreement about the TARP, the Troubled Asset Relief Program. Unlike the libertarians, the Chamber of Commerce wasn't economically opposed to the bailout, which relies on centralized body to promote the economic well-being of business, which is the Chamber of Commerce's mission. By contrast, the libertarians at Freedom Work initially thought of filing a constitutional challenge to TARP as a violation of the non-delegation doctrine, decided not to for procedural reasons, but there's a very a totally different attitude toward the bailout. What about Tea Party conservatives? How do they fit into this picture? They combine and are in tension with aspects of both pro-business conservatives and libertarian conservatives. So obviously the Tea Party was founded in opposition to the bailout, and this they share with the libertarians. But the Tea Party constitutionalists have a strong strain of social conservatism that's often in very direct tension with my friends at Cato. For me, this combination of a vision of the Constitution as a divinely inspired document and a commitment to resurrecting limits on federal power that are far more radical than even some of the libertarians were willing to recognize is encompassed in the founding text of the Tea Party movement. This is this book, Cleon Skousen's The 5,000-Year Leap. I'm just curious, because I'm writing about this now, who in this room has heard of this book, The 5,000-Year Leap? And who has never heard of this book before? All right, I'm not surprised. This confirms my intuition that you, Federalist Society, pointy-headed intellectual eggheads, you are the ideas elite. You got to get out into the streets more and into the rallies. This was the book that Glenn Beck endorsed in 2009. It was the best-selling book in the country. At Tea Party rallies, more people mention it than any other text. They're literally waving it. And it is it has directly inspired the most vigorous and coherent Tea Party senator, Mike Lee of Utah, who knew Cleon Skousen when he was a kid, and whose constitutional vision is directly derived from the 100 questions for constitutional candidates at the end of this book. So here are some of Mike Lee's constitutional views. And John, if you're worried about the death of limits on federal power, then go celebrate with Mike Lee, because here are some of the things that he argued for on the campaign trail. He said he proposed to dismantle on constitutional grounds the Departments of Education, Housing and Urban Development, and the Energy Department. All right, please, you can cheer as well if you really like some of this stuff. I'm interested, and boo if you're libertarians out there who don't agree. Let's sort of gauge the crowd on this. He insisted the Constitution doesn't give Congress the power to redistribute our wealth. That includes phasing out Social Security on constitutional grounds. A little more tepid, because we're getting down the slippery slope here. He proposed repealing the 16th Amendment, which authorizes the progressive income tax, and the 17th Amendment. Terrible affront to states' rights. I know those crazy progressives. Who knows what they did? He proposed to end the unauthorized federal occupation of Utah land on the grounds that Congress lacks the constitutional power to designate any wilderness unless the relevant state legislature approves. Who cares? Yeah, you go skiing in Utah, but you don't really care about Utah land, obviously. Okay, here we go. Here's my test. He endorsed nullification, the idea that the states have the right and indeed the duty to disregard federal laws like the health care bill when they believe those laws are unconstitutional. Nice to be back in the party of Calhoun. And he insisted that he would not vote for anything that did not have an explicit grounding of enumerated rights. As your U.S. Senator, he promised, I will not vote for a single bill I can't justify based on the text and original understanding of the Constitution, no matter what the court says you can do. All right, that you go for. And that's in the contract for America. But in addition to that, there's a very strong strain of Mormonism and social conservatism, including viewing the Establishment Clause as not being incorporated against the states, like our friend Akil Amar. He thinks the Establishment Clause should not be incorporated. There should not be limits on the state's ability to promote religion in a non-denominational factor. And the wall of separation metaphor, as Christine O'Donnell said in Delaware, appears nowhere in the Constitution, and the Supreme Court should repeal it. What's the response to that? All right, not a scientific study, but you know there's disagreement in the room among all these because you guys fall into different camps here. So what is this? And if I've identified the fissures between the Tea Party social conservatives and the libertarians, who would not be clapping at the Establishment Clause stuff. There's also strong tensions between the Tea Party conservatives and the Chamber of Commerce business crowd. The business community is very concerned about some of these Tea Party senators. Some candidates want to take aim at the $30 billion annual package of tax breaks for a range of businesses, including Wall Street firms, the timber industry, and so forth. Also, programs that businesses have accepted, like the stimulus bill, the Wall Street and auto industry rescues, the cash for clunkers car trade, the home buyer's credit. All of these are places where business interests favor uniformity, and the Tea Party is not on board. So what is the implication for these fascinating, meaningful fissures among conservatives for the litigation battles to come? Before November 2nd, I would have said that only Justice Thomas is the perfect Tea Party justice avant la lettre. That's that fancy phrase. Before the phrase was introduced, he combined devotion to religious conservatism, states' rights, and opposition to elites. And I love that section when he's talked on the road, when he was talking about his book, about how he loves to get in his RV and talk to real people in rest stops and around the country. Those are Tea Party people, and he really understood that impulse even before it was organized as a movement. So he deserves credit for the coherence of his vision. But I would have thought before November 2nd, maybe only he might have gone for some of this healthcare stuff. Now I'm not at all so sure. It's true that Ken Cuccinelli, who's doing such an effective job leading these lawsuits, is going to make the constitutional arguments that he makes, but you can distinguish away the cases that John Eastman talked about. I have to say, John, I would have thought it not plausible before November 2nd that anyone could invoke Justice Breyer's Comstock opinion as an argument against healthcare. I mean, it'd be the farthest thing from his mind, but Ken is going to do a good job in telling us why Comstock clearly requires the court to strike down healthcare. And just predictably, I think there's a, I'm not a great vote counter on this. I'll be interested in my colleagues' thoughts, but it's by no means implausible that the court might actually go for it. But should they? Should they? And here I want to leave you with my passionate invocation of the importance of judicial restraint. So the courts get into huge trouble when they embrace constitutional visions that are vigorously and intensely contested by a majority of the American people. And it's true the Tea Party has just had some victories, and you guys are much more cheerful than you were 2 years ago, but the Tea Party constitutional vision, the vision of W. Cleon Skousen, is by no means accepted by a majority of Americans or even of conservatives. William F. Buckley famously denounced Skousen in the 50s for his John Birch views. Respected conservative writers in the Weekly Standard and the National Review have called Skousen an extremist. There is no national constituency for striking down the EPA and Social Security, pace Mike Lee. I mean, this is just a very fringe, ultimately a very distinct minority of people support this. I'm not saying that striking down healthcare would be the same as striking down the Department of Education, but this is a slope whose slipperiness, we all know where this is going to end, and at least Justice Thomas and Professor Skousen and Senator Lee have the courage of their convictions and are willing to recognize where these arguments go. And I think that if the court, ahead of schedule, embraces a vision that is endorsed by some, but by no means a majority of the country, it may well provoke a backlash that could make the one in response to 1937 look tame. And we know what backlashes can do. Maybe then Justice Kennedy would get cold feet, and in yet another switch in time, he would say he was terribly sorry and change his mind and promise never to do it again. So I will leave by urging on you the lesson that I learned as a law student who used to go to Federalist Society meetings kind of covertly. I didn't want my friends to see me. And the dean, Dean Calabresi, caught me coming out of a meeting once, and I felt like I'd been caught coming out of a racy movie or something like that. But I did respect what I... Oh, you weren't... Yale in the 90s, good times. Those are exciting. But Federalists taught me in law school that political battles should be fought in the political arena, not in the courts, and judges should hesitate to strike down laws based on contested constitutional arguments that a majority cannot embrace. I'll argue in greater detail in the Q&A that it's now Democrats, liberals, who are more committed to upholding laws of Congress, and even if you add up the states in the aggregate, are less committed to using the courts to reverse their political defeats than conservatives. And if the Roberts Court historically strikes down on constitutional grounds the pillars of Democratic bipartisan legislation of the past decade, including not only campaign finance, but also healthcare and perhaps financial reform, then that court runs the risk of being tarred in history as the same kind of group of conservative activists that the court in the 30s was as well. So that's my final warning to you. Remember judicial restraint. Thank you so much.
Thank you, Jeff. I don't know whether you've shown that conservatives represent a big tent or how easily they can be divided and conquered. It seems to be one of the two. Our third speaker is a public official and litigator, and he is the current Attorney General of Virginia, and his name is Ken Cuccinelli, and he has taken a lead in the fight against Obamacare. So thank you, General Cuccinelli.
Give them a second. They have to turn it on. They turn it on somewhere.
Keep whacking it till you do it, or I'll just yell.
Here's mine.
Nice try. Of course, liberals respect judicial restraint now that the court has given them everything they couldn't get through the political process. And that is, in the political arena, not on this panel, a no-brainer, because they want to keep what they've won over and against the overwhelming opinions and the history, opinions of this country and the history constitutionally of this country. So of course they want judicial restraint now. I'd like us to get back to a point of balance. Today, I've been asked, while you've probably heard healthcare ad nauseum, I've been asked, since I'm in the middle of it, to give you a quick spiel on that, and then I'm going to address the ultimate question of this panel. And I want to start by thanking John Eastman, because I am usually the most pessimistic person on a panel. And John's going to make me look rosy, downright rosy, but before we get done here. Of course, there are two healthcare cases that involve states right now. By the end of January, I expect there could be as many as 5, maybe even 6, though I expect some of the potential new filers will join the Florida case, though not all. Right now, we are just awaiting an order in Virginia. We're in the Eastern District, the Rocket Docket, by far the fastest court in the country, and they're proud of it. And I practiced there as a private practitioner before I became a public lawyer, and we expect to hear next month. The judge told us before the end of the year. Some of us sort of anticipate that we will hear before the Florida hearing for summary judgment, which is December 16th. So in the next month or so, I suspect we'll have the first round of the what I'd call the big cases on health care, and those are the ones that involve the states. The two basic points of argument are related to the individual mandate and the penalty, which you will recall the president said is not a tax until the bill passed. And both of them as affected, of course, by the necessary and proper clause. So the individual mandate is argued by the federal government as being constitutional under the Commerce Clause. And when people talk about this case and this legislation being unprecedented, what they're referring to is the fact that the federal government has never before ordered Americans to buy a product, which of course they've chosen the selection of products for you, or at least mandated what they look like. And I would say, if you leave with one thought about the potential future impact of that case, it should be this: it is not about health insurance, it's about liberty. If they can order you to buy a product and penalize you monetarily if you do not obey, and that's constitutional, then they can order you to buy a car, they can order you to buy asparagus, they can order you to buy a gym membership, to use the examples the judge used. And shoot, we need more jobs in Detroit, right? So that would be a good thing. So maybe they'll, in fact, tell you which type of car to get. Maybe a Chevy Equinox. I own a Chevy Equinox. You don't want to own a Chevy Equinox. But you know what? There's nothing stopping it if this is constitutional. If they ordered you to buy one every 3 years, the price would be about the same as health care. Health insurance, not health care. There is a distinction. Race is, I believe, well understood to be the outer limit thus far of the Commerce Clause. I do not have as negative a view as John with respect to there being no boundary any longer. I do believe that in part what we're going to learn in this healthcare case is whether John's right and there's no boundary, or I'm right and there is a boundary and I just don't like how far out it is. And that'll take a little while. It'll take a little while. Nonetheless, this case is going to either set the new boundary or depress me to no end. And we'll find out. Thus far, one of the courts in Michigan, in the Sixth Circuit, notably, judge ruled that the individual mandate was constitutional. It was a very short opinion, basically adopted the federal arguments, lock, stock, and barrel, said decisions are the same as activity. That's the key leap of logic that they had to make to find that constitutional. Because if deciding not to buy health insurance is activity, and buying health insurance is activity, what can't the federal government regulate? Nothing. That's 100% of the field. There's nothing left. There is no limited powers left, if that's the case. I would say that I think the federal government's biggest hurdle to winning this case is the dictionary. Inactivity has to be activity. One of the comments made by the lawyer for the federal government during our argument was, the appearance of inactivity is an illusion. That's a quote. Some of them you just burn into your mind. And also, Section 1501B, which says you will pay a certain amount of money if you don't buy the Nancy-approved health insurance, the federal government says there's nothing punitive about that. Again, back to your dictionary, a big problem for them. And of course, they call it a penalty in the bill, but there's nothing punitive about it. There's nothing punitive about it. It is an extraordinary set of leaps of logic that have to be made, and language, for the federal government to prevail here. If disobeying a government order warrants you paying a penalty, and that's a tax under the taxing power, then they can order you to buy anything and penalize you if you don't, and it's constitutional. And you tell me what's left of unique authority for states that the federal government doesn't have. There's nothing left. If that's the case, nothing is left. Because anybody in here ought to be able to make people do whatever they want, one way or another, using that power. It is incredibly vast, incredibly vast. And then, of course, each of these, as is always the case, as it's affected by the necessary and proper clause. I would also throw out one fun little piece, and that is the severability provision that isn't there. Severability clause, for those who don't know, think of it in contracts. It's that last line that says if any part of this contract is found unenforceable, all the other provisions will remain in full force and effect, i.e., the bad provision is severed from the contract. Legislation has severability clauses as well. This bill does not have a severability provision. Now, that doesn't mean it falls if we win. It means the federal government loses the benefit of the presumption that the rest of the bill will stand if the individual mandate is unconstitutional. And the federal government has conceded in briefs that all of the insurance provisions fall if the individual mandate goes, because they're not sustainable. We would argue that at least that plus Medicare and Medicaid parts of the bill should fall, because they were calling it a financing provision in the motion to dismiss last summer until they lost there. They started changing their language at the summary judgment round so as to try and avoid the potential 100% loss of the whole bill. But that's where we are at this stage. We are looking to start talking to the Department of Justice about expediting the case because of the uncertainty that this the litigation over this legislation leaves hanging over not just state governments and us planning how and executing how we're going to implement the law, which if we lose, we will of course be required to do, and we're all doing in preparation in parallel with the litigation. But the impact on the private sector is equally, actually far more enormous. And if we can expedite the case and at least let everybody know what the rules of the road are, we can remove one cloud of uncertainty from over our economy. And my own view is that this administration underappreciates the impact of uncertainty like that like what's my tax rate going to be next year, on how the economy functions. They just have no clue about the connection between those things. It's why the rule of law is so important. It's a living example of it. And unfortunately, it is not appreciated by those currently in power. I used over half my time there, so I'm going to hurry through the agency portion of what I have to say and hope you ask good questions. I believe that the area that we're going to see the most confrontation on in the next 2 years with the federal government is coming through the agencies, because now you have divided Congress. They are well up to speed. The EPA is the politically correct agency of choice for most of the economically crushing regulation that this administration has been advancing. Much of it, or at least some of it, beyond the scope of anything these agencies have done before, and we would argue beyond the scope of their legal authority, which is the basis of us suing. We don't sue because we don't like a policy. We sue because we believe they've gone beyond their legal authority or they've violated the Constitution. Chevron, of course, is the uber deference case in the area of agency power. You heard Jeff mention the progressive era. That's where this regulatory state really began in this country, and it certainly began because there was this presumption in that movement that agencies are experts. Agency equals expert. Well, we're seeing science contorted, distorted horribly in alleged support of conclusions coming out of agencies, and sometimes unreviewably because they're using folks who are not in America, so we can't subpoena material, we can't lay our hands on the underlying materials supporting these conclusions. And at this stage, you really need completely standardless delegation from the perspective of the court for the delegation of that authority to be overturned. And since the New Deal, the Supreme Court has never found such an example of completely standardless delegation. The deference regarding findings of fact and how they apply is so high, arbitrary and capriciousness as a standard is extremely difficult to achieve in a litigation environment. And the price that the agency supposedly paid for this incredible deference is that they have to strictly follow their own rules and their own regulations in pursuing these courses of action. And they have to get that procedure just right. And our first lawsuit against federal government when I got in office was not the health care case. It was EPA over the greenhouse gas endangerment finding. We sued alongside Texas and Alabama. 13 other states joined us, including 4 represented by Democrat attorneys general. It's an entirely bipartisan effort by people who understand that the EPA is beyond the scope of its proper legal authority, and that the results are going to be economically devastating if some intervention doesn't take place from the courts. We also petitioned the EPA at the same time to reopen its case, if you will, still a litigator, its public comment process in light of the ClimateGate emails, the questioning of what they called peer review science at the time, and at least reconsider that and open it for discussion. The standard for them accepting that petition is that, if recollection serves correctly, new information that was not available during the public comment process that is central to the finding. Well, those 3 standards appear to me to be clearly met in the case of the ClimateGate materials, and they rejected our petition. The statute says shall grant the petition, so they have actually handed us a lower legal standard on this particular matter than an agency would normally have. And we intend to vigorously attack that point because we believe, at least initially, it's the best way in. I believe that we need something like a statutory consideration of economic factors in all regulatory action. Strangely enough, a cost-benefit analysis. What a wild idea. Figure out what something might cost before we do it. Radical. And that agencies must clearly demonstrate the benefits outweigh the costs. That should be an added standard that would help us bring back into balance what is a terribly out of balance Federalist structure. That's just one idea. It is one that could be done relatively straightforwardly. It makes so much sense that I'm pessimistic about its opportunity to prevail. But everything, I mean, everyone, I hit the EPA occasionally, but all of us, I would assume, want to keep a clean environment, to be good stewards of the world around us. But I hope you all also recognize that we're always striking a balance between the cost of improving the environment and keeping it clean and the opportunities to make a living and maintain a standard of living. The greatest forces for cleaning up the earth in the history of the world, and really the only ones that have ever worked, are two, and you need them both: free people and free markets. You need them both. And as we improve our standard of living and can afford more stringent requirements to benefit the environment, we should implement them. But this administration is so out of balance. We have a director of the EPA, the administrator, Lisa Jackson, who has said that economic consequences aren't her job, period. Well, she's sure acting like it. I give her points for bluntness. And unfortunately, that has horrible consequences for America and for Americans. And remember this, for the poorest Americans get hit the hardest. That's who's going to get hit the hardest and are being hit the hardest. I can see it in Virginia. I know what the differences are around my Commonwealth, and I know where it hits the hardest. There's a reason that Morgan Griffith beat a 28-year incumbent in Southwest Virginia. 3 words: cap and trade. And the greenhouse gas endangerment finding is just the agency version of it. Hits the same industries on the same timeline with the same impact, and it has the same detrimental effect to our economy, and they know who's going to get hit the hardest. And so they booted the guy who had been working for them for 28 years and who no one had ever gotten, I believe, above 40% in 28 years, and he lost this go-around. Americans get it. They understand we're out of balance, that we need to fix it. However, I don't think we're yet. I hope that John Eastman is wrong. Normally, I hope John Eastman is right. But on this, I hope he's wrong because he's even more pessimistic than I am. Congratulations on that, by the way.
Thank you, General Cuccinelli. I'm going to start off with a question for our 2 professors. Whether the Rehnquist federalism revolution is dead, life support, not doing very well, let me put to the side for a second. If there's one reason I don't think it's doing very well, is it never got the support of virtually anyone in the legal academy. And I've never quite understood that. I don't think of federalism as inherently liberal, conservative, Republican, Democrat. In fact, there are many parts of it that seem likely to attract my friends in the academy. They tend to trust courts over legislatures. That would lead to judicially enforceable limits. They don't mind counter-majoritarian protections. They don't mind checks and balances. They like protecting the powerless against the powerful. If you look at some of the recent cases, it's the powerless against the powerful. It's Raich, Lopez, Morrison, Comstock. Those are all individuals up against the federal government. And my friends in the academy don't mind what seems to be the hardest problem in federalism, is judicially enforceable limits with principles that judges can apply. I mean, substantive due process does not have principles that are easy to apply. I mean, you can't say federalism is worse than substantive due process. So why is it that the academy never supported it? And I guess the last point is, we don't always have control in one party. I mean, the Bush years should have been a great reminder that there are reasons to want to attack federal legislation. So why is it that the people in the academy never, even some of them, really got on board? I mean, Jeff, why don't I give you a shot at it first, and then John, I'd be really curious the answer.
It's a great question, and it's a fair question. And I'll talk very loudly. By people in the academy, obviously you mean liberals.
Well, I mean, law professors in general. I mean, John Eastman is an example, but he's an exception. There are not a lot of, I mean, you could have a cocktail party with all of the Federalist supporting people in the academy, and you wouldn't have to get more than 2 bottles of wine. It's not
Which
a
you
big
usually
group.
do for those, to get through those cocktail parties, you need more than that. There are law professors, liberal law professors, who support federalism. My teacher and friend Akhil Amar, both his Establishment Clause jurisprudence and some of his Commerce Clause work as well. Sunstein has some of it, but broadly the generalization is correct. Liberals don't like federalism. Why not? The answer is obvious. Most of the stuff that Congress has been doing for the past 50 years has favored liberals. And it's the same reason conservatives have rediscovered the virtue of federalism limitations, that they don't like the results. So that's the broad reality, and it's not shameful to say that. Liberals did get upset about Congress during the Bush years, but it was able to challenge the Guantanamo stuff not on Commerce Clause grounds, but on other liberty-based separation of power grounds, and we're happy with Justice Kennedy when he went along with that. But more broadly, it is true that there's been a resurgence of popular constitutionalism among liberal academics, and generally the flavor of the day is judicial restraint. Ken, I think it's a fair shot, but not ultimately a convincing one, that liberals want to keep all those Warren Court victories and avoid new defeats. Because from Larry Kramer to Sunstein to my little stuff that I've written that only my mother has read, many of us have criticized Roe v. Wade, are skeptical of judicially enforced gay marriage, take seriously the lessons of the New Deal. So there are some consistent devotees of judicial restraint in this crowd. But broadly, you're not going to get a lot of professors arguing for striking down congressional acts that professors like.
What do you think, John?
I do agree. Most of the legal academy is liberal, from left of center to hard left of center to just outright socialist, and precious few on the conservative side. Although largely as a result of this organization, that has changed. But there's been a dent made, and only a dent. I think, but among the conservatives, you don't find that many people leading the charge on this, and I think there's a good reason for that as well, and that is the first time we had big fights over states' rights turned on defense of slavery, and the liberals did a very good job tagging any states' rights claim with a defense of the Old South slavery, and it took a long time for people to kind of steel themselves to taking on that challenge, despite the name calling that would come from it. We've crossed that threshold now, and relatively rarely do you get that kind of name calling by defending federalism, and so I think you'll find a broader scope of it. But I think that kind of had the brakes on it for a while.
Yeah, and then you can respond, Jeff. Yeah.
John, that'd be great. In my last campaign, in my last debate, my opponent, who up to that day had been a friend of mine, opened the "you're a racist" attack because you support federalism. And of course, we were in Virginia, and Virginia has one of the worst histories in terms of its government oppressing its own citizens, African Americans, and violating their 14th, 15th Amendment rights, and as a matter of law. And he had no qualms about opening fire on that. And I don't think, in my adult lifetime, nobody has run on federalism principles as I did in '09 and had done at the legislative level before that in Virginia. So, the opportunity was there to have a clean argument, and the other side wouldn't do it.
Go ahead, yeah.
Just a brief thing on both of those scores. I agree it's completely unfair to tar defenders of federalism with the label racist, but it also would be helpful for the modern defenders of federalism to recognize that history more explicitly. So Cleon Skousen was from a generation where those views were accepted, and in the current edition of his casebook, there's still stuff on slavery, the happy slaves and so forth, and using racial epithets that are beyond the pale by any standards. And that 1950s era John Birch Society vision, some of whose aspects have been resurrected by non-Skousenites like Rand Paul in the opposition to the Civil Rights Act of '64, isn't helpful for those who are trying to separate a defense of federalism from a history that not too many people want to defend. So I think it would be great if you guys could just make that explicit.
Well, Jeff raised the good point about who's the party of judicial restraint. I mean, I must concede or confess myself, the first reason I came to Federalist Society meetings in the 90s was probably the issue of judicial restraint. And is he right that conservatives / Republicans, that the whole thing is switched now, and we're advocating an aggressive role for the courts now in significant areas of American life? It was said in Garcia back in the mid-'80s that 10th Amendment, 11th Amendment, other structural guarantees really weren't judicially enforceable. They were really enforceable through the ballot box. We've just had an election which suggests that's not entirely ineffective. So can we be principled in advocating what you're advocating, Ken, in your case, and John, in some of the cases you've litigated?
I mean, look, the opposition to judicial activism that was the genesis of this organization was a judicial activism that made up newfound rights from penumbras of emanations of unenumerated powers, and then use those kind of both define the scope of the constitutional right and then use that kind of self-definition to strike down laws they didn't like. That was the vintage thing. When you're talking about striking down laws that actually do violate the text of the Constitution, I don't think that's judicial activism. Now, the left has made a very concerted effort to try and equate those two things, and we ought to oppose that at every opportunity because it's just not true. When you accept the proposition that the Constitution has a fixed meaning and that the role of the judge is to inquire and understand that meaning and apply it, and it's straight out of Marbury versus Madison. If the law and the Constitution are in conflict, the higher law of the Constitution has to prevail. But you only get there with legitimate authority in the courts if you're actually applying the Constitution as written, not as you would like it to be, or finding something that's not there and then using that to strike down the law. And that's the difference between the two, it seems to me.
I would say that first of all, I agree with John in that response. I think that we have the problem now where the judiciary, frankly, has run wild for decades. Present company accepted, of course. But
Worst things have been said.
I know the feeling. And how do you correct that? The obvious way to correct it is judicial correction, but that just, that's the modern version of judicial activism for people who don't choose to remember back past, 1980. And then they say, well, you're changing the Constitution because you've gotten rid of our penumbras. Well, there never were any penumbras. Look closely, stare hard, you won't see them. And now we've gotten ourselves in a cycle. It's, this is the judicial version of Israel and Palestine. I mean, who calls truce and says, okay, we won't do it anymore? And I don't think, as a matter of human nature, that ever happens. I think that we will never reach an equilibrium point. We are in a dynamic society. The people in this room don't agree on one single clause of the Constitution, I would venture to say. Maybe we could find one. But the point is that there is a certain amount of flux about this, but the radical rewriting in the face of the text of the Constitution has to be undone. And you can't just say, well, you got to get 3/4 of the states to approve something that 2/3 of your both bodies have written for every single time that's happened. And so the only really reasonable way to do it is to expect judges to correct those errors, no matter how old they are. Now, Scalia would tell you, 20 years once it's set in, then it kind of becomes part of the fabric of the Constitution, because upsetting it then causes more disruption than putting you back on the right keel in the first place. So, I don't think there's a clean answer to this question at all. And we can debate who's the activist, who isn't. I was on with Elliot Spitzer last night, and speaking of activists, and they introduced me as, the conservative Elliot Spitzer, and I'm thinking, shower, and if it's activists to go fight for the text of the Constitution If that's an activist, again, that same old problem with the dictionary obviously goes beyond the federal government.
Well, Jeff, I want to let you respond, but in your response, maybe one point you can address also is, you're a believer in judicial restraint in general, I'm hearing, right? Across the board, individual guarantees, structural guarantees. When it comes to structural guarantees in states versus federal government, are there judicially enforceable limits? So, but respond to them, and if you have a chance to talk about that, that'd be great.
Great. I'm trying desperately for a microphone. There we go. This one should work. It's not true that the Federalist Society was founded just on the altar of textualism. It was also founded in opposition to economic judicial activism. So there was a totemic, significant debate in the 1980s at Cato between then Judge Scalia and Professor Epstein. And Professor Epstein made his wonderfully convincing case in favor of economic judicial activism. He said Congress is running amok. There are a whole bunch of regulations that are ripe for a quick and easy kill, and basically endorsed an aggressive judicial stance. Justice Scalia got up and said, this is a siren song for judicial conservatives and we have to resist it. The whole point of the Lochner era was that we learned the dangers of striking down economic regulations in the name of shadowy doctrines that might have some textual rooting but were not clearly rooted in text and history. We have to be principled and stick to our guns now, and we should avoid trying to use the courts to strike down regulation. And that division persists today, is my little distinction between the Chamber of Commerce people and the libertarians suggest. But look, we've been talking about 6,000 debates. There have been 10,000 about the meaning of activism, what's a restraint. If we're talking about deference to legislatures, if you count up the numbers, Democrats are in favor of deference. And it's true that there's some inconsistency with liberal justices who denounce activism for federal laws but are willing to strike down state laws. But the people who've counted up the numbers, and Thomas Keck at Syracuse has done it, have found that when you combine the federal and state laws, the most restrained justice on the court is, of all people, Justice Ginsburg, who's just generally not voted to strike down a whole lot of laws. As for your tough follow-up question, do I think there are any structural limits of federalism? Justice Scalia, of course, asked that question to Justice Breyer. It may have been in Lopez, and Breyer dodged it. He didn't really answer it. And this is not my field, so this is not a considered answer. But it strikes me that when it comes to quintessentially economic activity, as long as Raich and Wickard and Filburn stand, there are no limits. When it comes to non-economic activity that is said to have a substantial effect on economic activity, then maybe you could apply Justice Breyer's Comstock test, and maybe even Justice Breyer would find, and I think I would agree, that something like requiring people to buy Hondas or asparagus would fail the test because it's not plausibly part of any regulatory scheme that has a public purpose. I can't reel off those 5 mushy criteria, but some things could fail it, and forcing people to buy asparagus probably would.
I love the Federalist Society's notion of giving everyone an equal voice. We've given you 3 microphones. I think.
I still feel silent.
Well, I think what's going on is they turn them on after you've started talking. So I think all 3 of them actually work, believe it or not. But you're probably wondering, did he give me all bad mics? They didn't want me to hear. I think that's how it's working. Ken, you had a response.
Yeah. Just a quick comment, because obviously I'm an attorney general, but I also got elected to this position. So I am in several different arenas at once. I try to prioritize legal decision making and then figure out political consequences later. I have not found that to be universally the case across the country in this position. But I want to split one hair, and it's more of a political split that Jeff mentioned. He mentioned as an intellectual conflict the difference between what chamber conservatives and Tea Party conservatives might want. I totally disagree that that is the basis of that conflict. The basis of that conflict is moolah. The chamber conservatives want whatever will make them more money. And this is why the problem we're in today, I've said this administration because I'm contending with the specifics of it, it reaches back past 2008. This is not a Democrat problem. This is a bipartisan problem.
Let's get some people from the audience. Why don't we start at this end and go ahead. If you could introduce yourself first, that would be great.
Mike Paulson, University of St. Thomas. Putting political hypocrisy of the Obama administration aside, John especially, why isn't this sustainable under the taxing power, the individual mandate?
The question was, why is this not sustainable under the taxing power? First of all, ordering you to buy a product, this was one of the arguments with Elliot Spitzer last night. He wanted to treat making you buy that product as the equivalent of paying the government taxes. That has never happened before, and it should never happen. The government needs taxes. They have certain powers to levy them, and that's how we fund our government. Making you go buy other products has never been deemed a tax, and it should not be deemed a tax. It has never been deemed a tax in history for the money you pay because you fail to obey a command of government, and so you pay a penalty to fall under the taxing power. If that's a tax under the taxing clause, again, that's even broader than asparagus and cars and everything else, and frankly, you could just create a regulatory regime where asparagus was a key element, a linchpin, to use the federal language, and you're right back where I started from, and that is that they can make you do anything if this is a constitution.
And if it is a tax, I want to know what kind of tax it is. It's not a tax tied to income. It's not an excise tax. It's not an import tax or a duty. That means it's a direct tax. And a direct tax has to be according to population, not by what percentage of your population complies with the mandate and not which. And so it would violate Article 1, Section 2. I mean, so they're in a bit of a box there. They're trying to claim that it's a tax in one litigation and not a tax in the other litigation where the direct tax apportionment argument is made.
And don't forget, the president said declaratively, and he's a constitutional scholar, it's not a tax.
Why don't we try from this side? Go ahead.
Eric Lippman, also of the Minnesota chapter. Twice in Professor Rosen's remarks, he raised the specter of Lochner-era backlash by the populace generally for some of our views to get popular. I'd like to drill down a little bit and ask each of the panelists to opine if Dean Eastman's view of the limitations on the spending power were actually to become the view of the Supreme Court, to become binding precedent, as he had hoped with the Eighth Circuit case. If that were the view, do you think that would prompt the kind of backlash that Professor Rosen warns against? And I'd be interested for all the panelists' views. Thank you.
Yeah, I give a lot of thought to this, because what does it mean in its full implication? You know, I start by saying from your lips to God's ears, and the new members of Congress are going to confront this. Are we going to defund NPR? You know, are they going to take it and defund the education department? You know, all of these things that flow. And given things that people over 73 years have relied on in federal spending and their pensions and what have you, do you unravel that? That's politically unpalatable. And how do you take the politically unpalatable off the table without undermining the principle itself? And those are very tough prudential questions. I do think you can start small. One of the reasons I like the Cisney versus Raich case up in South Dakota is it was federal spending for local prisons. It doesn't get any more local. It doesn't get any more core to state sovereignty. It doesn't get any less moving in interstate commerce than that. And that was a good place to start to kind of establish the principle while we then kind of figure out how far we can carry that's politically palatable.
I would just say that the best analogy for the reaction, though not a perfect one, will probably be actual budget cuts when they hit, kind of the example John used. When they're actually implemented, I think you'll see the same kinds of popular reaction that you would see there. But I will say that if it happened now, the Virginia experience after we had major budget cuts last year was the only people who screamed were the special interests. The people of Virginia get it, that we have to do this, and they accept that, and they're ready to do it. They're ready to do it. They're more ready than all of us. What are we? Pointy-headed? What are we?
That was a compliment.
I know. I want to know. But, the intelligentsia or whatever will be the ones who gnash their teeth and scream and wail. The people of America get it. They get it, and they're ready for it.
And I want to take up something that I think the Tea Party represents on this, and I think it's a much broader movement than even those that identify with the Tea Party. The notion that because we've grown so accustomed to these subsidies of agriculture or of General Motors or of New York City or of individuals or all of these things, that we've therefore embraced them and accepted this kind of constitutional alteration, this constitutional moment, as Bruce Ackerman refers to it, is contradicted by the language in the Declaration of Independence that will suffer abuses while they remain sufferable. You can't distinguish between suffering abuses while they remain sufferable and ratifying the change and it not being abuse. And I think what Tea Party represents is that a whole lot of people in this country have crossed the threshold from sufferable to insufferable abuses. And we'll have to see how far that carries. But there are a lot of people that think the last 70 years have been abuses, and they're finally saying, we're going to stop the abuse and start unraveling it.
So there's a history on this, obviously, and this has to do with the history of the progressive era. The court, during the progressive era, struck down the progressive income tax, and it was repudiated by a backlash that was embodied in the 16th Amendment. It struck down minimum wage and maximum hour laws, and the backlash was initially not national. It was limited to certain states, but eventually culminated in the New Deal and the repudiation of the conservative court there. So every time progressive movements succeed in getting substantial laws passed, the Supreme Court, a conservative court, has tended to strike it down, and in the past that has created a backlash. So that suggests that this Warren-era bit of activism was a blip. More broadly, the pattern has been the one I described. Will there be a similar backlash now? It depends on the success of progressives in mobilizing popular opposition to the court. So one thing I really respect the Tea Party movement for is having recognized that this economic populist vision does have a broad political constituency. And my friend and teacher Larry Lessig has just called for the creation of a neo-progressive movement that would share with the Tea Party opposition to the bailout, to banks, to the curse of bigness, the stuff that Ken was talking about, denouncing the money chamber vision. There is an opportunity for common ground here. So far, President Obama has not gone after the banks. He hasn't mobilized a popular consensus around economic indignation, which would make a popular reaction less likely. And after all, the Rehnquist Revolution, which I know you are all in mourning about as a kind of tepid response, was met with indifference by the public. People didn't care, it turned out, about the scope of sovereign immunity, believe it or not, because the court wasn't striking down stuff people really cared about. Now, if the Congress defunds or the court strikes down NPR, you're going to see a lot of people in Birkenstocks marching in the street.
Mark Middleman from St. Louis. Following up on really the last three remarks of each of the panelists, I'm not, as far as I know, a Tea Party conservative, nor do I know very many of them, but I do know one thing about them, and that is that they're not very likely to allow themselves to be characterized by a Harvard-educated, inside-the-beltway law professor who writes for the New Republic and who tells them that they're really the followers of W. Cleon Skousen, who, as far as I know, never said anything that anybody listened to from about 1964, maybe, to Glenn Beck. And the point of all this is a populist movement which we, insiders and elitists, aren't defining. Is that fact that it's a populist, anti-elitist movement the game changer for purposes of how the court, which follows the election returns, is going to view all of these issues of enumerated powers, the 10th Amendment, et cetera, into the future? Is it the game changer?
I would say that first part of your question, or part of the answer to your question, depends on how judges react to these sorts of public movements. What is most extraordinary about what I'll just characterize as the Tea Party movement, it was mentioned earlier that that's just really a part of a bigger movement. What you see in those Tea Party protests is just a small piece of a much bigger movement. What's amazing is how organic it is. It's, and I don't mean like, you know, the Raich case. I mean, like, I mean, like it just pops up in every community because it's based on principles. You don't need a person to lead a movement based on principles, and they've stayed fairly focused. I'd characterize what they focus on as more in the libertarian streak, which conservatives share on economic issues, but they have been focused like a laser beam, to quote someone they would probably never follow, on those very narrow issues. And the future impact of that is potentially enormous. I mean, millions of people in this country are changing how they think about candidates, about politics, about policy, and they're reading it, stunningly enough. So maybe more than Jeff's mom will read the next thing he writes, whether they agree with him or not. But people are reading it now. People are showing up at town hall meetings having read bills congressmen haven't, and knowing a lot more about the subject matter. It makes for, C-SPAN's never been so interesting. I mean, it's amazing.
Don't push it. Jeff, go ahead.
The Harvard bashing was a nice touch, but the truth is that it's not me who's telling Tea Party people that they're advocates of Cleon Skousen. They told me that. So I may be a pointy-headed professor, but I'm also a journalist, and I've spent the past 2 months learning from Tea Party rallies and learning and being impressed, as Ken said, by the people who read the Constitution and have their own vision about it and are agitating for it. And I don't share that view, but I deeply respect citizens who are going to take the time, often on their own dime, to come to Washington and agitate for the Constitution. And these people told me again and again, you have got to read this book. They were carrying it. I'm writing about this for the New York Times Magazine next week. You can get the quotes. This is Joe Walker, a Tea Party activist from Binghamton, who told me that Skousen had taught him that other nations have fallen into disrepute because they look to government for the solutions. The solution is the people. I talked to a teacher from Albany who said that she wanted her school district to start teaching the works of Skousen, and that her fifth grade son who was there had learned so much from his vision. So I'm just a reporter here. I'm a pencil with ears, as has been said. And this book, which you should read, because you should have enough respect for this popular movement to want to know what is inspiring it, is very much at the center of things. Will this influence the justices? This is a complicated question of how the courts respond to populist movements. And I think I agree with Ken's instinct and would say the justices certainly, many of them have not heard of this book, although Paul Skousen, W. Cleon Skousen's son, told me that 2 justices had attended the Skousen seminars and were admirers of the book. He wouldn't tell me which ones, and I had my guesses. But I think that the court doesn't go to the rallies, but it definitely looks at what's going on in Congress. It was not a coincidence that the Rehnquist court federalism revolution got up and running in 1995, the year after the Republicans retook Congress, and therefore they will be paying close attention to what this Congress does and what it's defunding, and the efforts to repeal health care congressionally, and that will very much affect the climate in which the constitutionality of health care is evaluated.
Sure. Ramon Buehler from Virginia. I was a counsel for Congress for 14 years, and I started with the belief that politicians and the judges they appoint could be relied on to limit the growth of government. And it struck me that people who spent their entire political careers seeking power, once having it, find it extraordinarily difficult to give it away. Judges can sometimes resist that, but if you look at judges, they tend to follow, by 10 or 15 years, the political majorities that elected the presidents, that appointed them, in the Senates that confirmed them. So my question is, if the goal is limits on government power, is it not necessary, in addition to relying on the judicial power, to restore the state's power that the founders intended them to have to propose individual amendments to the Constitution without the risk of a runaway convention? And if the people have the power and the states have the power to limit the growth of the federal government, isn't that, in the long run, a lot more reliable than relying on judges that are appointed by the Washington politicians who are abusing the power?
I don't take my proposal to get the judges re-engaged in the game as an alternative to that. These things all supplement and complement each other. I think we ought to have an amendment that lets states propose individual amendments. I think we ought to have an amendment that lets states collectively rescind acts of Congress they don't like. I think we ought to have an amendment that lets states challenge Supreme Court interpretations of amorphous language in the Constitution that they don't like. I think we can have a constitutional amendment that has a series of Me Too things. When it says commerce among the states, it means commerce, and it has to be among the states. I think when it says general welfare, we ought to have a constitutional amendment that says it needs to be in the national, not the local. That means general, not local welfare. We could go through a whole lot of necessary and proper means it's got to be proper and necessary and not anything else. So we can. But the problem is if you don't have the judges engaged in that game, no matter how tight you make that parchment barrier, you're going to have future Congresses ignoring it, and if you don't have future judges holding them to account, we kind of hold the line for a little bit, and then it's back to the races again.
Just one comment on that. If the now widely held belief is that constitutions evolve, I'm not saying majority, minority, then why bother with any of this? Frankly, why bother with a written constitution in the first place? It is, to me, the highest form of arrogance of power on the part of a judge to do other than to simply try to apply law or the Constitution as it was written when it was written. The methods exist, the means exist to alter those laws and those constitutions. They should not be in the hands of the judges. I mean, I'm speaking simply here, but it's helpful sometimes with lawyers to start with the basic stuff. I speak for myself most especially, but we have judges. I mean, I famously, most recently, read Thurgood Marshall's comment about how ridiculous it was to think you should read the Constitution the way it was originally written. How outrageous from his perspective. Well, then why do we bother writing them? Why do we have laws? Why don't we just do Greek democracy and majority vote for everything, and we'll just fight over what the count is? And that's where that leaves us.
Quickly, you may not need a constitutional amendment to make it easier for amendments to pass. My teacher and friend Akhil Amar tells us that maybe an amendment, proposed by a majority of states and ratified by the people in a thoughtful deliberation day might count as an amendment outside Article 5. But I would hope that the takeaway of this good, discussion this afternoon would be why focus so much on amendments as the source of constitutional change? We've just agreed that it's popular movements. The Tea Party has changed the Constitution already, and how dramatically it will change it is going to reflect its interaction between Congress and the courts and the president and the people, but just the rigid formalism that says that only constitutional amendments can reflect constitutional change is obviously rebutted by the huge difference in our constitutional culture today as opposed to 2 years ago when all you guys were so depressed. So you should learn from your victories and recognize how significant the achievement of having fomented this popular movement actually is.
We have time for one more, maybe two questions, depending on how quickly they're asked and answered. Go ahead over there.
I'm Kai Alberg from Port Angeles, Washington. Over the last 75 years, we've seen a one-way ratchet towards more federal power and diminished state sovereignty and diminished individual autonomy. What is the panel's view on how to assure continued survival of federalism long term? And I don't mean just the next few election cycles. We've seen in '94 the pendulum swing one way. In 2006 it swung back. This year with the Tea Party movement it swung another way again, but that will not last forever. Is it by way of constitutional amendment? Is it by way of some other means that you think is the most promising avenue?
Years ago, I published a chapter in a book called "Stare Decisis: Conservatives' One-Way Ratchet Problem," and you got to tackle it. If you've got courts for a period of time that don't think they're bound by the Constitution, when you get courts back in authority that think the Constitution is binding, they can't hold the line. They've got to unravel some of what has been done. And there's a wonderful quotation in Gulliver's Travels to this point. "Stare decisis is a maxim among lawyers, that whatever has been done before may legally be done again, and therefore they take special care to record all the decisions formerly made against common justice and the general reason of mankind. And I think we have got to unravel that problem.
Federalism is important, and I have lots of libertarian instincts, but maybe we should recognize that at the moment, the greatest threats to liberty, free speech, libertarian values, come not just from the government, but from companies like Google and Facebook, which have more power over free speech and who shall speak and who shall be heard than any king, Supreme Court justice, or government. And they're not doing a terrible job at this right now, but the challenge of how to regulate the private sector at an age when they have more power over liberty than many governments is a challenge that both Tea Party conservatives and Louis Brandeis era progressives should be able to think creatively about together because of a shared concern about the curse of bigness, whether corporate or governmental. So let's not, these 4,000 debates have been great. I look forward to the next 4,000, but let's not be so mired in old debates to think that the problem the founders were concerned about, which was threats to liberty, may come today from very different sources.
If you're interested in that point, you should read Jeff's book, The Unwanted Gaze, which is very good. Last question over here.
Ruben Borchardt from New York City. Professor Rosen mentioned that Rand Paul opposed the Civil Rights Act. With respect, I just want to correct that. He opposed the portions that address what private actors have to do, and there's a big difference. What the portions that address what government must do, much if not all of it, simply reaffirms what the Constitution says. The portions that oppose what private actors have to do nothing but infringe on individual rights, including rights to hate and discriminate, which are repugnant but protected by our Constitution.
That's a very helpful refinement, and I appreciate it and accept it, although it reminds us that Rand Paul libertarian vision might be opposed to the very challenge that I just raised. Although equally concerned about free speech, he would be very reluctant to regulating the private sector, whether it's Google or Facebook, for precisely those reasons. Interesting challenges ahead.
So, last question. Here we go.
Mr. Cuccinelli, the administration has advanced the argument that because the health insurance market is different from other markets, namely that everybody at some point in their life will have to use health care, that it can regulate it with something like an individual mandate. I was wondering where the precedents are for that distinguishment and how you plan on confronting it.
When we had the summary judgment hearing on October 18th, if I remember correctly, the first question out of the box for the judge for the federal government was, if this is constitutional, what are the limits on federal power? And the universe of the answer from the federal government was exactly the questioner's point. Well, healthcare is different. You know, end of story. It was never explained how it's different. The presumption is because we'll all need it. Well, we all need to get around. We all need transportation. You know, Lord help us if we all weren't here wearing clothes. We all need to eat. We all need a lot of things. And I mean use need the way the dictionary does, not the way, congressmen do. So there are an awful lot of things that fit in that category. That is not, in my view, a principled distinction. I mean, that's a list we argue over. And again, I go back, Walter Dellinger, Clinton's Solicitor General, when we were on a panel at the Washington Legal Foundation after that hearing, answered the question. I think he's the only one I've encountered so far who's answered it accurately. He said the limits that you have left are political. But that begs the question, why have a constitution? Why have a constitution at all? And again, this is one of the challenges, in my view, the federal government has in prevailing in this case. The main thing they have going for them is this presumption that they always win. But that's it. That's not much of a basis. And the alternative is that if the states lose, even according to one of those inside the Beltway law professors, Jonathan Turley, George Washington University, federalism is dead. And I agree with him. Then I'm in the John Eastman camp. But that's how close we are, and it's really a sad measure of where we fall into jurisprudentially, that there's one case, in my view, that stands between us and the end of federalism, one of the critical elements of the Constitution that the founders passed on to us for our own protection, the protection of liberty and our citizens. and the sovereign entities within that system. And we're on the verge of seeing it go away.
Jeff or John, do you want to respond? No? You all set? Okay.
I'll just pick up on this. You only get that question if they've bollocksed the spending clause issue in the first place, because it's only by the federal government making these spending things that they now have a whole bunch of people that are going to take advantage of that spending, that they try and impose the mandate to perform. So let's get the courts back in and trying to, funding somebody to go to their local hospital is not interstate commerce, and it's not spending in the general national welfare, it's vintage local welfare. And that's not within the powers of the federal government. And if you got people to start enforcing that line, you wouldn't need to try and figure out other ways to pay for it, like individual mandates.
Join me in thanking all of our panelists.